services don't modernise, the consumer has no way to demand the modernisation of them. You know, they're just presented with, here it is, this is what there is. If there's no opportunity for choice, then the consumer can't really make that need felt. It just has to keep taking whatever's delivered. And I think that's maybe the case at the moment, unfortunately.
Would you really rather not have a service regulated by the judges of the High Court, particularly if it were a legal one, than some consumer watchdog? Whose business is speaking to a court to act professionally in the interests of justice and the interests of me, would I not really much prefer them to be guided by under the regulation of the Lord President than any other organisation?
Well, I can't personally see what's wrong with independent regulation that's properly regulated with all the proper safeguards. You know, I think that's one thing that we're very keen to see, is that high level, and I think that's by and large what's being proposed in the bill.
Okay, thank you. Can I bring the OFT in? You've seen the ground I've covered. Thank you.
Firstly, trying to deal with your points. On the direct access aspects, I totally appreciate that we're talking about small percentages, but it's really a question of choice. It's for maybe the very few at the moment who may wish to do so, but it's really ultimately a question of choice of if they are sufficiently educated enough or familiar with the court process to go directly, and ultimately it's also it would be up to the individual advocates concerned whether they wished to offer their services direct. I mean, direct access is in England and Wales, and there are a number of barristers who don't wish to go down that route. So it's really a question of choice for both sides of the transaction. On the regulation aspect, yes, the advocates are a small number, 460. Obviously, the bill now provides in the faculty to be subject to the regulatory objectives. It doesn't affect the role of the Lord President in his in his sort of role with the faculty. The issue really is one of the members, choice for the members, whether they wish to not just provide their services via the independent referral bar, whether they wish to form partnerships or to join with others.
So you're concerned that advocates might themselves feel restricted in their current environment and might actually themselves want to do something different?
Right, and I think there is evidence to say that there are advocates who wish to adopt different business models.
Yeah.
James Kelly, please.
Okay, thank you, Convener. I think you'll be aware of the Solicitors Guarantee Fund, which essentially ensures that, no member of the public, can be defrauded by a solicitor, and it provides, essential protection. Do you agree that that's currently a scheme that benefits the public?
Yes, indeed it is, and we wouldn't want that protection lessened for people using legal services in any other arrangement.
Do you accept that the introduction of alternative business structures may potentially undermine this particular fund, and therefore undermine protection to the public?
I don't particularly see how that will necessarily happen.
How then do you see the fund as it operates currently, being implemented as we extend into alternative business structures then?
I suppose that's a matter for the people taking part in the scheme to work out, I suppose. I mean, it's like the master policy. I mean, we would like to have more competition introduced in that, so there's not just one provider, because I think that has a potential conflict for interest. So I think it's maybe a good time to look at these areas. I do agree with that, yes.
But would you agree that if you have a system currently where all solicitors contribute to the fund, and then you change your business structures to extend the businesses into other areas like accountants, that there are difficulties and, you know, if you like, imposing such a levy on other professions.
I suppose that's part of the regulatory conflict that has to be worked out between the professions so that consumers are as protected as they are now. And different professions have different schemes, and I think that's something that has to be worked out, obviously, amongst the professions who might want to be involved.
OFT, do you have any views on this?
We would wish that the guarantee fund would also apply to ABSs, because we wish consumers to be protected whether they go to a traditional form of practice or whether they go to an ABS. I think there is a way to ensure that the guarantee fund can apply to ABS. How that's done is obviously a matter for the regulation, but I believe that in England and Wales there is a levy, because it's called the compensation fund there. There's a levy on anyone who is registered to practice offering legal services in an ABS.
Okay, moving on to contingency fees, we've had an indication from the Minister that, you know, he doesn't tend to move forward with that now. Have you got any views on the application of contingency fees?
Well, the OFT's view is that any mechanisms, you know, funding mechanisms which give consumers choice to secure funding to get legal services can only be a good thing. How you regulate that and how that's done, then that's something we'd have to see the proposals, really.
What's your view of the principle that if someone takes a case forward for compensation, for example, and they win that case, and, you know, they're awarded, say, £100,000, do you accept the principle, as some have put forward, that, you know, that should be awarded in full, you know, to the claimant, and any other costs, you know, should be attributed, you know, to the losers in the case as such? Well,
I mean, there's lots of different, I think, systems of funding at the moment in England and Wales, and a lot of flaws being identified, and I think that is one of the flaws, that you have these systems where a lot of the damages are then recouped by legal fees. Well, that obviously can't be right, so there must be different ways to devise that both the consumer and the provider will get their appropriate share of the outcome.
Ms Clarke, have you got any views on this area?
Well, obviously there are difficulties with both contingency and conditional fees, but on the other hand, if it's a case of no access to justice or this, then obviously this is better than no access to justice.
Just going back earlier to the issue of the new regulatory regimes, how easy do you think that will be for, you know, consumers of legal services to understand? I think people, when they're buying a house, for instance, they use legal services, you know, but rarely perhaps for the average person, and they want it to be accessible, understandable. They want to know who's getting money for what, who's getting paid a fee for what that cost is, and to know that there is competition so that they're getting a good deal. I'm not saying that every consumer will come along and understand the whole regulatory background, but if the safeguards are in this bill, then to some extent it doesn't matter, just as it doesn't matter in some ways that they don't understand the whole framework now. It just has to be easy to use at the time and easy to access if something goes wrong. OFT, have you got any views?
Yeah, I think there are perhaps two additional points. One is that we do believe that consumers do need to understand the rules and the systems and the services that are available to them, and that I know there have been various comments raised about the possibility of covering public legal education in this context, because actually as citizens we rarely understand enough about how our legal system works for us. And this may be a trigger for some of that new information for consumers. I mean, the provisions of this bill are bound to be complicated, and the issue will be how that can be communicated well for consumers, whether it's one of the inimitable guides done by Consumer Focus Scotland or whatever, that it will need to be very clear to them what the changes are and why, and what they mean for consumers. And that's something further down the road. Maybe something even in the way of a diagram that demonstrates where all these different bodies sits is important. But I do think that there is this wider question of how much we really understand how our legal services work for us as consumers.
Robert Brown.
Thank you very much, Convener. Just before we leave the guarantee fund thing in